Yes, she has. She signed it in April for Bahamas.
The Honourable, the President.
We welcome you to the 22nd sitting of the Senate in the first session of the 11th Parliament that takes place on Tuesday, June 21st, 2016.
Let us pray. Almighty God, we willingly acknowledge you as the Supreme Being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honorable Senators, in accordance with Standing Order 79-2, I wish to make the following appointment to the Senate Sessional Committees for the first 2015-2016 session of the 11th Parliament. Statutory Instruments Committee, Mr. Rohan Sinanan in lieu of Mr. Hafiz Ali. House Committee, Mr. Wade Mark in lieu of Mr. Vasan Bharat.
Bills brought from the House of Representatives, petitions, papers.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper and supplemental order paper in the name of the Ministers of Finance and National Security and the Prime Minister. The annual report of the Central Bank of Trinidad and Tobago for the year ended September 30th, 2015. The annual report of the Auditor General of the Republic of Trinidad and Tobago on the consolidated financial statements of the Trinidad and Tobago Unit Trust Corporation, the UTC, for the year ended December 31st, 2015. The consolidated financial statement of the Petroleum Company of Trinidad and Tobago Limited for the year ended September 30th, 2015. The administrative report of the Tobago House of Assembly, 2015. The Defense Force Rates of Pay and Allowances Amendment Regulation 2016. And finally, Madam President, the Defense Force Rates and Pay and Allowances Amendment Number 2 Regulations 2016.
Reports from committees.
Senator Mark.
Madam President, I have the honor to present the following report as listed on the supplemental order paper in the name of Senator Michael Coppin. The fourth interim report of the Joint Select Committee appointed to consider and report on the Whistleblower Protection Bill 2015.
Urgent questions.
Senator Mark.
Thank you, Madam President. To the Honourable Minister of Trade and Industry. In light of recent reports that 5-year-old chicken parts are being sold to consumers, what immediate measures will the government be taking to protect and safeguard the well-being of consumers of poultry products?
Honourable Minister of Trade and Industry, you have 2 minutes.
2 minutes?
2 minutes.
2 minutes? Okay, fine. Thank you very much, Member. May I just say that this question of food fraud and food safety, all of these issues are very, very serious issues. We see it of paramount importance for the consumers of chicken. Chicken, as you know, is one that is consumed by the majority of the population, and of course is a considerable source of protein. So, and naturally, it's quite a large industry within Trinidad and Tobago, so it's very important to us. It's a cross-cutting issue in terms of across several ministries. It is that, and you will know that, your government will know that we have not adopted any food standards for poultry at all. This was an agenda, an item which was agreed on by the COTED, which is the Council for Trade and Economic Development in CARICOM. And so that a CARICOM standard, after consultation with the Caribbean Poultry Association and in accordance with the OIE as a benchmark, international benchmark for the WTO when it comes to animal health issues, this standard was approved but not implemented by the last government at all. As you know, it's a voluntary standard, and however, we as a government would wish to consider whether we would make it a compulsory standard. And I'll tell you why. As it is, a number of ministries are involved with the actual importation. So I can't say for certain, and I've checked it in the short time that I've had, and over the weekend as well, I also delved into it. I can't say for certain that there are, in fact, five-year-old chickens imported into Trinidad and Tobago. What I do know is that it involves the Chemistry, Food and Drug Division of the Ministry of Health, and they rely on a health certificate which is given by the, for instance, chicken coming in from Trinidad, they rely on that health certificate which is coming in from the U.S. Department of Agriculture. And that would have the country of origin and so on. I do not think that the date of issue is there.
Honourable Minister, the 2 minutes. Your time is up. Yes. Yes.
Yeah, Honourable Minister, could you indicate to this Honourable House when will action be taken to standardize via and implement through legislation and regulation the decision taken by COTED in terms of ensuring the well-being of citizens who consume poultry products?
Honourable Minister.
Madam President, action is being taken, and as I can tell you that the Bureau of Standards has been looking at the actual the standards, and looking out for all of the quality problems which exist in the industry. And there's going to be a cross-functional approach to this with the involvement of the Ministry of Health, from the Chemistry, Food and Drugs Division, the Ministry of Trade in terms of consumer education as well, and the Bureau of Standards with their involvement in terms of the implementation of the standard as well, and the Ministry of Agriculture. Public Health under the Ministry of Local Government, Rural Development and Local Government will also be involved. But we consider this a serious issue, and this government will be continuing until the actual standard is implemented. So we will be moving with speed, with alacrity. This is a very, very urgent issue. Thank you.
Senator Ma.
Madam President, rather, in light of the urgency and action required as outlined by the Honourable Minister, could the Honourable Minister indicate to this House whether she's aware that the Chemistry, Food and Drugs Division laboratory has not been functioning for a few months well, and in light of what is taking place and the action that you have proposed, what measures will be taken to get this laboratory or Food and Drug Division function efficiently and speedily?
Yes.
Yes, Madam President, it has not been months, it has been years. And therefore, the member would be advised that they should have full knowledge of this matter. The lab has not been functioning, I believe, for about 2.5 years under y'all, and nothing was done about it. But it's an urgent matter. It affects all other issues, all food, all drugs, all cosmetics, the testing for which now is done by Kariri and so on. It's a matter that was being looked at closely as we speak, and we have been looking at it, and it is being given urgent attention.
Senator Mark.
Thank you, Madam President. To the Honourable Minister of Works and Transport. Given the recent flooding and dislocation experienced by residents of Debe and Penal through persistent rainfall. Could the minister state what assistance, if any, will the government render to the affected residents?
Honourable Minister, Honourable Leader of Government Business, you have 2 minutes.
Thank you, Madam President. Madam President, we had some excessive rainfall this weekend, which from a point of view of water management, we welcome. However, it has affected the residents of Debe Penal in a way that has caused some flooding. As you're aware, the Penal Debe area is on the fringes of the Overpooch Lagoon, and what happens there is that there's so much backfilling for residential building that the water doesn't have enough channels to run. But having said that, this question is largely based on what assistance will the government render. Madam President, there is a robust social safety net in place in Trinidad and Tobago. For example, there's a disaster grant for home repairs, which all affected residents can access. It's 20,000 for home repairs, 20,000 for electrical, and 20,000 for plumbing. So if you are really, really badly affected, you have access to as much as $60,000 in that regard. There's also a short-term rental policy that if your house is not habitable for a period of time, you can get 3 months rent up to a maximum of $7,500. Clothing, if your clothing has been destroyed, $1,000 per person. So if there are 6 people in the household, you can access up to $6,000. School books for primary school children, $700. For secondary school children, $100. And obviously, there's also the temporary food card that will be accessible to affected residents. So I think Trinidad should feel proud that we have such a wide safety net for affected people in disaster, and I think this is comparable to any part in the world. I thank you.
Senator Mark.
Madam President, could the Honourable Minister indicate whether the areas that he has mentioned under the social safety net, could he indicate whether these areas are properly funded and resourced at this time so that people can access those areas?
Madam President, I'm pleased to announce that this section of the government services is very much well resourced, and all these grants are accessible once there's a legitimate request for them. And obviously, if the area has been flooded out, there is a legitimate basis to access these resources.
Questions on notice, questions for oral answer.
Madam President, the government is pleased to announce that we will be answering all 3 questions listed on the order paper today.
Senator Mark.
Thank you, Madam President. Question number 63 to the Honourable Minister of Planning and Development.
Leader of Government Business, you have 5 minutes.
Yeah. Madam President, the loan value for the project strengthening of the single electronic window, SEW, for trade and business facilitation, the loan value is US $25 million. The repayment terms are as follows. Amortization period, 25 years, with semi-annual payment installments. Disbursement period, 5 years. Grace or amortization period, grace period, 5.5 years. Or moratorium for another phrase to use here. Interest rate, LIBOR base, currently 1.85%. Based on LIBOR of 0.63%, plus funding margin of 0.07%, plus the IDB spread for capital loans of 1.15%. Madam President, the interest rate for this loan is a mere 1.85%, an amortization period of 25 years, and a moratorium of 5 years. There's a credit fee payable on the undisbursed balance of the loan at a percentage set by the bank periodically during its review of financial charges on ordinary capital loans. The credit fee, however, shall not exceed 0.75% per annum and will begin to accrue 60 days from the date of signature of the loan contract. Madam President, this is the nearest thing to free money.
Madam President, could the Honourable Minister indicate when would he be making available to this Parliament the actual loan agreement which the government is compelled to do under an agreement arrived at some years ago. Could you tell us, Madam President, when will that loan agreement in full be tabled for the viewing of the senators and by extension the national community?
Leader of Government Business.
Madam President, the loan agreement, the loan contract was signed by the Honorable Minister of Planning and Development in the Bahamas in April of this year. I stand guided. I'm not certain if those loan agreements has to be tabled in Parliament, but in the interest of transparency, I will surely seek to find out if that is the case, and if it is, there will be no problem.
Madam President, I'm surprised that the Honourable Minister is aware of it, but there is an undertaking by government which came about as a result of an agreement that all loan agreements, whether it's IMF, IDB, or what we have here, would be tabled.
Senator Mark, what is the supplemental question?
Well, I'm just trying to ask the Honourable Minister if he can give us an undertaking to report within next week, within the next couple of days, that particular position, and make available at the same time that loan agreement.
I think that the Minister previously, for the first supplemental, gave a response. I don't think that what you just said requires a response from the Minister.
Okay.
Senator Mark, question number 64.
Yes, question number 64 to the Honourable Minister of National Security.
Honourable Minister of National Security, you have 5 minutes.
Thank you very much, Madam President. Madam President, barring any unforeseen circumstances, it is expected that the policy for the payment of the 1 million compensation for the families of officers slain in the line of duty will be finalized by the end of June, and the note will be submitted to the Cabinet for its consideration and approval, Madam President.
Thanks, sir.
Senator Mark.
Yeah. Question number 65 to the Honourable Minister of Labour and Small Enterprise Development.
Minister of Labour and Small Enterprise Development, you have 5 minutes.
Thank you. Thank you very much, Madam President. Madam President, the government of Trinidad and Tobago is deeply concerned about the loss of jobs through any means, whether it is through layoffs, retrenchment, or termination. We understand the devastating effects of job loss on workers, their families, their communities, and the nation as a whole, Madam President. The loss of one job not only affects one's livelihood, but can have long-lasting emotional and psychological effects, which can further impede on one's ability to rise out of unemployment into sustainable work. Madam President, while there are mechanisms in place in Trinidad and Tobago to assist unemployed persons to obtain sustainable employment or create jobs through entrepreneurship, as well as a wide range of social protection measures to provide income support, we have taken note of calls for the establishment of an unemployment insurance scheme in Trinidad and Tobago. Such a measure was proposed, Madam President, by some stakeholders at the Ministry of Labour and Small Enterprise Development recent national tripartite stakeholder consultations on the Industrial Relations Act, Chapter 8801, held on February 22nd and February 23rd, 2016 in Trinidad, and in Tobago on April 8th. This issue was also raised at the workshop that we held on contract employment, reducing the dependency, which was held on April 13, 2016. Given this government's commitment to tripartite engagement and dialogue with stakeholders, we would no doubt wish to fully explore this idea with stakeholders. We would need to engage in a national conversation, since such programs require careful and detailed consideration. The issues to be considered include eligibility, benefits level, and duration, timeframes for application of the scheme, financing, effects on consumption, effects on employment, effects on poverty levels, and economic trends. We have already enlisted the assistance of the International Labour Organization in providing information on jurisdictions where such schemes have been implemented with success and methods and processes of administration. Madam President, it is within this context and against this background that we look forward to working alongside the relevant line ministries and state entities on the engagement of stakeholders on this important topic in the very near future.
Madam President, may I ask the Honourable Minister, in light of the worsening economic situation in our country and the laying off of so many workers, whether the Honourable Minister intends to fast-track this particular mechanism so that within the shortest possible time frame we can bring to the Parliament the appropriate legislation to address this particular matter, which is of grave importance, particularly to those workers who are being laid off and have no income to turn to. Madam President, could the Honourable Minister advise whether this matter will be given top priority? And she will come back shortly.
Madam President, while I understand the concerns, I think we must understand that consultation cannot be fast-tracked. Consultation is a process because you have to engage various stakeholders. They have to convey their views. The views have to assess, distill. And whilst this government is cognizant of the fact that there are people out there, there are workers out there who are suffering, I want to make the point that this government, Madam President, is a mere 9 months of age, and we have done much more than the last administration did in the last 5 years. But notwithstanding that, Madam President, I hear members of the other side demanding that this government must do X and Y. I want to assure the workers of this country and the national community that this government cares about their welfare, and we are working as fast as we can to bring relief. But I think they will understand that consultation takes time.
Senator Mark.
Madam President, could the Honourable Minister indicate whether it is her intention to present very shortly to the national community a white paper on this very important subject for discussion and via the consultation process, having regard to the urgency of the matter?
Honourable Minister.
Madam President, I don't think I can add any more to what I have said earlier. This government is moving with dispatch. We are engaging with various stakeholders, and the process has started.
Request for leave to move the adjournment of the Senate on definite matters of urgent public importance, statements by ministers or parliamentary secretaries.
Honourable Attorney General.
Thank you, Madam President. Madam President, in November 2013, on November 13th, 2015, I made a statement that Trinidad and Tobago had undergone the Caribbean Financial Action Task Force, or CFATF's, fourth round mutual evaluation process to assess our compliance with the Financial Action Task Force 40 recommendations, which are the international benchmark for an effective domestic anti-money laundering, combating the financing of terrorism regime. This process assessed our AML CFT systems as of January 2015 and entailed a rigorous examination of our laws, policies, and enforcement track record. The mutual evaluation report was adopted by the 42nd CFATF plenary in November 2015. But the report was also subject to what is known as FATF Global Quality and Consistency Review and Analysis by FATF. The finalized report was made public on June 3, 2016. Trinidad and Tobago knew the mutual evaluation was on our horizon. The third round mutual evaluation was completed in 2005, and we were placed into enhanced follow-up and monitoring by what is known as the ICRG. The PNM administration then faced these challenges head-on, taking steps to address these technical deficiencies by enacting 4 key pieces of legislation. These laws became the backbone of our AML-CFT legal framework and are the basis for improved ratings for technical compliance in the 4th round. In February 2010, FATF publicly acknowledged our progress in improving our AML-CFTF regime and called for continued work on implementing our action plan to address remaining deficiencies. While we were removed from the ICRG process in 2012, we remained in enhanced follow-up. The momentum gained by February 2010 was not maintained, and Trinidad and Tobago did not address all deficiencies required to exit the 3rd round by November 2014 as scheduled. CFATF only allowed us to exit by merging the remaining deficiencies of the 3rd round mutual evaluation into the 4th round evaluation. The results of our 4th round mutual evaluation clearly demonstrate that after 2010, too little was done to address our technical deficiencies. Gaping holes were left in our AML-CFT regime. We were rated non-compliant for recommendation 7, which is targeted financial sanctions against weapons of mass destruction, and 8, which is the non-profit organizations, and only partially compliant in respect of a further 13 recommendations. These include fundamental recommendations such as recommendation 1, which is assessing risks and applying a risk-based approach. A national risk assessment was not completed in preparation for the mutual evaluation. Policymakers had no empirical data against which to test the efficiency of legislative policy or operational measures. The country was shooting in the dark for solutions to national and international problems with a cascading effect of non-compliance with other recommendations. As a result of these gaps, we now face the challenges of a 3-tiered FATF-CFATF monitoring process. We were placed into enhanced follow-up requiring more regular reporting to CFATF, with our first follow-up due in May 2017. This will obviously put tremendous pressure on our country's time and resources. Madam President, effectiveness is judged against 11 immediate outcomes set out by FATF. A country qualifies for referral to ICRG of both CFATF and FATF if it has low or moderate effectiveness for 9 or more of the 11 immediate outcomes. Madam President, we were rated as low moderate in all 11. And because of the size of our banking sector, which is roughly US 15 billion, we qualify for automatic referral to ICRG at FATF and CFATF. This will be no walk in the park for us, obviously. We need significant improvements in our technical compliance and effectiveness to exit ICRG, and we cannot exit enhanced follow-up without first exiting ICRG with both FATF ICRG supervision and CFATF, and obviously in those circumstances we may very well find ourselves on the FATF grey list. This could lead to countless dire consequences for our citizens and economy, such as de-risking of local banks, additional customer due diligence requirements, multinational banks reconsidering their positions in our local market, and increased delays and cost of doing business in this country. Madam President, fortunately, this government predicted these threats long before entering office, which is why we made our AML-CFT reform a key component of our published legislative agenda, prioritizing a suite of legislation which must be amended or enacted to bring our country into technical compliance. We have already drafted several powerful pieces of legislation to plug the gaps in our AML-CFT framework and towards taking the profit out of crime. Amendments to the Financial Intelligence Unit of Trinidad and Tobago, the Mutual Legal Assistance in Criminal Matters, the Customs Act, the Exchange Control Act, and the Companies Act will be brought to this Honourable House before the end of this calendar year. Amendments to the Proceeds of Crime Act and the Financial Obligation Regulations will shore up our defences, Madam President, and when put alongside civil asset forfeiture, which is Explain Your Wealth legislation, we will finally put us in a real and meaningful position to protect our natural patrimony from the savagery of corruption. The Credit Union Bill, Cooperative Society Amendment Bill, Insurance Bill, Gaming, Gambling and Betting Control Bill, and legislation to regulate trusts and amendments to the Income Tax Act are all on our legislative agenda. We have taken a comprehensive view of this issue, adapting a whole-of-government approach to AML-CFT. We do not operate based on theory. Our solutions are fact-driven. We have moved swiftly to complete the National Risk Assessment as a foundation for compliance with all FATF recommendations and immediate outcomes. The Office of the Attorney General and Ministry of Legal Affairs established an anti-terrorism desk, which lists individuals and entities as terrorists and freezes their funds. I have also convened ad hoc multi-agency task force to tackle deficiencies in our anti-terrorism and anti-terrorism financing framework, allowing for a quantum leap in interagency cooperation. Madam President, in June 2016, the UN Regional Center for Peace, Disarmament and Development in Latin America will work with us on legislation on the proliferation of weapons of mass destruction, legislative and administrative systems to address non-profit organizations, and very importantly, unmasking beneficial ownership for both legal persons and legal arrangements are aggressively in train. This is a fundamental element of AML-CFT framework which has inexplicably been left unaddressed for far too long. Legislation on a non-conviction-based confiscations will address gaps with respect to mutual legal assistance. In that vein, this government has already appointed the Seized Asset Advisory Committee, which was not done since the law was passed. We are not only seeking technical compliance by enacting legislation, but we're ensuring that these laws are fully implemented and properly operationalized. A national action plan is being finalized to address all 11 immediate outcomes and will position us to exit the ICRG process in the shortest possible time. Work is, however, already underway in several key areas. We are examining all international conventions relating to anti-terrorism to determine where our country is non-compliant. I have also initiated an assessment of the current investigative procedures regarding anti-terrorism financing, which should also yield a framework to manage money laundering investigations. In December 2015, Madam President, my office successfully listed for the first time ever the first individual as a terrorist and froze his assets. Further listings to United Nations Security Resolutions 1267 and 1373 are currently in train, and these matters are before the courts right now. Our legislative agenda clearly demonstrates the priority we place on AML-CFT issues, but this is not a fight which the executive can win on its own. It requires a demonstration of patriotism and devotion to country by all members of this honorable House and in the other place. The 11 immediate outcomes speak to areas which fall within the remit of constitutionally independent offices, including the judiciary and law enforcement agencies. However, government remains committed to providing the resources and creating an enabling environment for the judicial and law enforcement agencies to fulfill their mandate. These are matters necessary to protect our citizens, Madam President, and to which this government gives the highest priority. Madam President, I thank you.
Senator Mark.
Madam President, could the Honorable Attorney General provide to this Senate what he described as the 11 immediate outcomes which have been imposed on us by FATF and FATF? Could you briefly give us what those 11 immediate areas are?
Honorable Attorney General, you have 2 minutes to give your response.
Madam President, 2 minutes would not do justice to the volume of work which the fourth round mutual evaluation report discusses. It is imperative, therefore, that members access, and it's published on the CFATF website, and I will make it public on the AG's website as well, the entire fourth round mutual evaluation report, which was published on the 3rd of June. There's been a long train to get us there, 3rd round, then going to 4th round. And it is not as simple as disaggregating, because the matrix as a whole must be put together. But I will certainly put the portal on the AG's website at www.ag.gov.tt, and also it is on the CFATF website, and then compare it against the legislative agenda which we have, which I have already spoken to.
personnel explanations, introduction of bills, motions relating to the business or sittings of the Senate, and moved by a minister.
Leader of Government Business.
Madam President, I beg to move the following motion. Be it resolved that this Senate agree to the appointment of Mr. Rohan Sinanan in lieu of Mr. Hafiz Ali on the following committees. 1. The Joint Select Committee on Land and Physical Infrastructure, and 2. The Joint Select Committee on Social Services and Public Administration.
Honorable members, the question is that this Senate agree to the appointment of Mr. Rohan Sinanan in lieu of Mr. Hafiz Ali on the following committees: the Joint Select Committee on Land and Physical Infrastructure and the Joint Select Committee on Social Services and Public Administration. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The motion is carried.
Public business, government business, bills second reading.
Honorable Attorney General.
Thank you, Madam President. Madam President, I beg to move that a bill entitled An Act to Make Jurisdiction for All Family Matters and Children Matters exercisable in the division of the High Court to be called the Family and Children Division, and to make provision for matters connected therewith, be now read a second time. Madam President, the standing orders of the Senate permit me only 45 minutes to discuss what is literally a massive work undertaking and work product before us. Permit me in the very short time that I have to traverse the bill, etc., to reflect upon what is before us. You see, there's a tendency by some to look at the fact that we're dealing with one bill before us today, to oversimplify where we have come from, what we have passed through, and what we now have before us. Today in the Senate, we now have for the second reading this bill. In the House of Representatives, the bill, when piloted there, resulted in a pause and a referral to a Joint Select Committee pursuant to Standing Order 69 of the House of Representatives, where 5 members of the House of Representatives were appointed to consider the work behind this bill. Similarly, pursuant to Standing Order 67, the Senate, before the second reading, not in the same position as the House, pursuant to its Standing Order 67, referred this bill by an equal number of senators appointed from this House to meet with the 5 appointed in the House of Representatives. The Joint Select Committee, established therefore by both Houses, sat on Friday, April 1st, 2016, Friday, April 8th, 2016, Friday, April 15th, 2016, Wednesday, April 20th, 2016, and Wednesday, April 27th, 2016. The members of the committee comprised me acting as chairman, Mr. Randall Mitchell, MP, Ms. Ayana Webster-Roy, MP, Ms. Ramona Ramdial, MP, Mr. Barry Padarat, MP, Ms. Khadijah Ameen, Senator, Ms. Nadine Stewart, Senator, Mr. Hafiz Ali, Senator, Mr. W. Michael Coppin, Senator, and Ms. Melissa Ramkissoon, Senator. And we considered, Madam President, material presented for the first time in a consistent pattern by this government, not only the bill before us, but we produced for consumption by all members the bill, the track change marked up version between the 2016 bill and the 2015 bill, which the opposition then as government had brought to the Parliament and which lapsed. We considered a consolidated amended version of the legislation. We tracked all of the changes, and we demonstrated to Trinidad and Tobago not only the principal content of this bill, which is to create a division of the High Court to be known as the Family and Children Court, but very importantly, along that jurisdictional carving that we did, we traversed the 18 pieces of law which we went through to harmonize and operationalize this law at the same time. You see, Madam President, the 2015 version of the bill brought by the then government, now opposition, comprised roughly 7 parts, 47 clauses, 3 schedules, and it amended 3 pieces of law in very short order across 3 pages. Roughly about 23 pages of a bill, just putting it simply. In the current bill before us, we have gone to 6 parts, 63 clauses, 5 schedules, and in Schedule 5 in particular, we now seek to amend 18 pieces of law. We had the option, Madam President, of taking this law piece by piece, and we could have brought it to the Houses of Parliament, produced 18 bills if necessary, but it was by far more sensible an exercise to take this work product, package it in the manner which we do now, and so amend 19 pieces of law in total. Now, permit me for a moment to reflect upon some of the legislative history. In fact, Madam President, the history of this bill started in 2001, some 15 years ago. There was the Family Bill 2001 brought in the Senate. It unfortunately lapsed when the Parliament dissolved. It then reappeared in 2007 as the Family Court Bill 2007. It again lapsed. And then it came again in 2009 as the Family Court Bill 2009, when the judiciary intervened and said that there were some fundamental architectural changes that they wished to effect. And so they invited the then PNM government to retreat from the bill and to cause amendment. The gestation period between 2009 and 2015 then happened. And very importantly, the judiciary came to be in receipt of, and I wish to express gratitude for this, United Nations aid funding, where the judiciary stood as a beneficiary of USAID grant development to produce what was called a juvenile court system for Trinidad and Tobago and a youth court. That was matched right alongside bringing into legislative form the experiment which was the family court and which is reflected in the explanatory note of this bill. Trinidad and Tobago would know that we as a jurisdiction, carved out by way of an experimental pilot project in the judiciary, the manner in which we treated with family matters by the creation of the family court for the District of St. George West. For those of us who have practiced in those courts, a very wonderful and meaningful experiment which very much informed the manner in which we amended the civil proceedings rules, and in fact the manner in which we have now published the criminal proceeding rules, which will come into law on January 17th, be operationalized on January 17th, 2017, having already been published under this government. I say that because we have taken the opportunity to marry the family court experiment and the children's court, as we now call the juvenile court experiment, putting those two together. But what the judiciary has done is rather unique. At first, when I considered this legislation in 2015, brought then by the government, I asked myself aloud and on the floor of the Senate, why do we want to affect the Supreme Court of Judicature Act in the manner that we do? Isn't it, as a framework piece of law, good enough to allow the Chief Justice, by his direction, to modify his court and to apply it into positions? That was the open question because the law permitted it. However, the answer which came then by a deeper drilling down was that the administrative structures of the judiciary intend in this bill to set the track record for all other divisions. So let's put it into context. We have a Supreme Court of Judicature in Trinidad and Tobago, which is comprised of the High Court and Court of Appeal. We have the Summary Courts Act, which deal with our summary courts. We call our summary courts the magistracy. In one area of the law, they deal with both civil and criminal jurisdiction, and then the Supreme Court deals with both as well. The administrative structure was such that we are now putting into law an administrative structure cast into law as opposed to one which the Chief Justice applies from time to time. And the reason given to me for this is that it is by far better to define the boundaries, the circumstances of operation into law, rather than rely upon the voluntary participation of people who work in the system. We now create a subdivision of the High Court, a division of the High Court, a subdivision of the Supreme Court of Judicature, We now have the Court of Appeal on the top. We have the High Court, which has as a division the Family and Children Court. And what we do is to take the Family and Children Court, cleave them apart because of the learning which stands behind them. We take the Family and Children Court, we park all of the family law matters, which in fact stand as a schedule to the bill. I believe it is the first schedule to the bill. When we take that first schedule and we look to it, you will see that there are several pieces of law which we can deem to be laws in relation to family matters. And we've scheduled it out in Schedule 1, including Administration of Estates, Succession Act, Immigration Children's Act, Status of Children Act, Age of Majority Act, Family Law, Guardianship of Minors, Domicile and Maintenance Act, etc. All set out. What we do next is to then take all of the children matters, so family matters and children matters, being two very critical definition pieces which stand in the bill, because the courts are now intended to operate on what we consider to be family matters and children matters. And what we do, extremely importantly, is to marry the jurisdiction of the magistracy with the High Court. You see, the experience right now is, for instance, where you wish to enforce maintenance orders and certain other orders in the magistracy, including in particular a very important area called domestic violence. A protection order must be approached in the magistracy, maintenance orders approached in the magistracy in some circumstances, but we had people going through the indignity of having orders in the magistracy where the High Court came in to be involved. Say, for instance, someone had approached the court for a divorce or a children matter, and we had two courts running concurrently. And you would have parties shuttling between the magistrates' court and the High Court. What this bill does in a very powerful fashion is to marry the jurisdictional experiences between the magistracy and the High Court, so you have what is referred to as wraparound services, where you can access one court and get the suite of remedies available to you. That is a first for this country and a step in the right direction. It is not only a cost-cutting effort, but it is an efficiency effort. Very importantly, women will no longer need to go to the domestic violence court, get a protection order, and then try to have the High Court ignore that order and send you back to the magistracy. Not in today's world. Very importantly, maintenance orders which apply to the Act, which is set out in Schedule 2 to the Act, to the bill. These orders can now be put into effect by a children court, by a family court, sitting in various circumstances, where you have family court judges, family court masters. We do something further. We take the benefit of the clerk of the peace experience, and what we have done is to clean up that exercise and have the clerks of the peace now operate as the registrar of the Supreme Court, the assistant registrar, assistant marshals. And we have migrated away from the experience of the clerk of the peace as is applied in Trinidad, because it wasn't quite what was intended in the original context. But we've taken the option to clean that up. The architecture of the bill itself, across the 6 parts, is quite an interesting one. Basically, in this bill, what we have are some mirror conditions which apply between the family court structure and the children court structure. The first part is the preliminaries, short title, commencement, interpretation. The second part deals with the creation of the division of the High Court called the Family and Children Division, how we set up the court, etc. The third part comes to deal with the administration of the Family and Children Division, and as I mentioned, taking into flow there the assignment of the deputy registrar and marshals, assistant registrar and deputy marshals. And then we get into the court administration. And here is where we legislate an organizational structure intended to be a prototype to be applied across the divisions of the Supreme Court. Here we put in the establishment of the Court Administration Department. We put in the Deputy Court Executive Administrator, Family Court Administrator, Children Court Administrator, the staff. In Part 4, we create the Family Court, And we give it, very importantly, in Section 9, Clause 9 of the bill, the authority and jurisdiction in all family matters exercisable by the family court. But if you stick a pin for a moment, you compare Part 4 with Part 5 of the bill, you will see traversed across Clauses 9 to 24 of Part 4, which deals with family court. When you compare that against Part 5, which is the children's court, where we have sections, clauses 25 through 39 inclusive, down through 40, straight down to 58, you will see that there are some provisions which can be mirrored. In particular, I would invite members to look at the mirroring of terms and conditions between Clause 9 and Clause 25, Clause 10 and Clause 26, Clause 11 and Clause 27, Clause 12 and 28, 13 and 29, 14 and 30, 16 and 31, 17 and 32, 18 and 33, 20 and 34, 21 and 35, 22 and 36, 23 and 57, and 24 and 58. And so we have traversed through the marriage of jurisdictions, summary court with high court for the authority in family matters and for children matters. We have assigned family court judges. We've assigned family court masters. They shall have powers of a judge. We assign the family court masters, and the powers of family court masters are set out. We assign the powers of family court masters to be the same as a family court judge. And very importantly, we deal with staff, management, oaths of secrecy, restrictions on publication of proceedings so that you redact so people can't be identified. We deal with the ability of the family court or the children's court to appoint a guardian ad litem on the request of the children's attorney so that you can have the voice of the child preserved in these circumstances. We deal with the transfer of matters and appeal of matters. Those are the mirroring provisions. Let's look to some of the powerful punches in the legislation. Section 15, Clause 15, deals with the enforcement of certain orders. And we are putting a nuclear device, in essence, to people who are the beneficiaries of maintenance orders, orders in relation to matrimonial property. Very often persons who are the beneficiary of these orders find that the cupboard is bare or somebody is just not listening to the court order. Warrants have to go out, you have to track down the people, they're dragged before the court, delay after delay. And Clause 15 allows for the implementation of what is referred to as a show cause notice. That show cause notice can be invoked to say why you should not have the registrar of the court step in, effect the transfer of your property without your participation. Of course, due process is observed, you're given notice, you're invited to come to the court, but it is a very powerful tool for the judiciary to apply at the invitation of a party who wishes for it to be implemented, so that we can treat with one of the ills when we deal with maintenance orders. And that's where enforcement of certain orders is tied into Schedule 2, as I had pointed out a little bit earlier. Importantly, you heard me mention a short while ago the voice of the child, Madam President. This is a concept which is an evolutionary step in the judiciary. We have migrated away from what is in the best interest of the child to include the protection of the voice of the child. And very importantly, we are now permitted by the establishment of the children court as a division, as we do now, a subdivision of this division, to have some extremely powerful provisions put in. You see, beyond the mirroring sections of the family side versus the children side, as I've just described, we now have the benefit of having the voice of the child dealt with in avoiding recidivism, the constant revolving door where children find themselves in conflict with the law. Our structures were just too rigid. A child runs away from a family, from a children's home, what was referred to prior to this law coming into effect, God willing, as a youth detention center or a juvenile center. Run away, you're obliged to put them right back in. Our laws, which stand in pari materia with the legislation which we now treat in the consequential amendments, were a little inflexible. And what we've done on this occasion is to now add a few very powerful provisions onto the children side of the equation. Number one, children probation officers. Number two, proceedings to deal with peer resolution. Number three, children drug treatment court process. Now, I've focused on those three. Proceedings for peer resolution are found in clauses 40 to 46 inclusive. Children drug treatment court are found in clauses 47 to 56 inclusive. When we look to the establishment of children probation officers, we look to clause 38, clause 39, and we recognize in clause 37 that the judiciary is permitted to have a constant supervision of the child so that there is a constant reporting. And what the architecture of this bill does is to now take into effect having the auxiliary services available to the court of a specialized nature, where you get people who are appropriately selected as having the mindset for this area of the law to work as probation officers, child psychologists, children police, if you want to use that expression, insofar as the Trinidad and Tobago Police Service has had the benefit of this government's agreement by cabinet of the establishment of an entire unit of the police force comprising hundreds of persons to work alongside the system. Improving the coordinate relationship between the Children's Authority, which is in a rather invidious circumstance. It is a regulator and a facilitator. And they are expected, with a minuscule budget over the years, to perform miracles, quite frankly. They have been thrust into the deep end of the equation, and particularly with the inexplicable operationalization of the children, foster care and nurseries legislation under the last government. That inexplicable proclamation of a clause which caused the situation in Trinidad and Tobago for every child in remand to be in the position of being deemed to be unconstitutionally detained because the centers were not built before the law was proclaimed. I just can't understand how that happened. All I can tell you is that today Trinidad and Tobago is now paying hundreds of thousands of dollars per person so remanded. And the Children's Authority has been thrust into the mix to try and find a regulatory framework to allow that to come to effect. But when we look now to the manner in which the court can permit supervision, we are now introducing, in a host of amendments, the ability to have a child detained in circumstances such as Section 54, where you can actually release the child not only back to children's home or children rehabilitation center, but into the custody of a parent. And that's a very important tool in the arsenal of reducing recidivism and protecting the voice of the child and factoring the best interests of the child. When we look to peer resolution set out in clauses 40 to 46, we see that we are now permitting an alternative dispute style mechanism entrenched in the law to facilitate children being participants in a process of supervision by their peers. Now, obviously, you don't just throw them into a court and tell 12 to 19-year-olds to just come up with a decision. There's a process of training for the peers. There's a process of judicial supervision for the peers. There's a process of resolution management for the peers, so that peers, who in fact can include people who have passed through the system and graduated themselves, get to have the reciprocity with the child who is in the peer resolution process. Very often, as we had in the public fora that I have hosted as Attorney General in relation to the age of the child and emancipation issues of the child on underage marriage, I can tell you many a young person has come forward and said, listen, where's the voice of the child? What do children say about this? How do they participate in it? As a parent to 3 teenagers, I can tell you, no matter how many qualifications you have, your children believe you are unqualified to tell them what they are thinking or feeling. And that's just a fact that I would imagine every father experiences or every mother experiences from time to time. There is that distance between the teenage evolution and the adult position where you feel as if you just don't have it right. And therefore, this mechanism of peer resolution comes to be a very important tool in the arsenal. Madam President, I'm particularly bad at timekeeping, so I would just ask you how much time I have left.
20 minutes left.
Thank you very much. Appreciated. Usually my colleague would hold up a little sign for me, but she's lost in her own work. So, Madam President, peer resolution forms a fundamental architectural position for us in this mechanism. Let's look now to the concept of the child in the position of the children drug treatment court process. Clauses 47 to 58. We are allowing another significant development in the management of children in the drug-related issues that they are faced with, to have an alternate forum called the Children Drug Treatment Court process. This is putting legislative clothing on another worthy experiment by the judiciary, which was funded, which was carried out on a child development practice basis, and which has produced significant results, which the Honorable Chief Justice has spoken to on many occasions. Now we are allowing, where any court comes to understand that a child has a problem with drugs, with alcohol, with certain influences, we are allowing a referral to a Children Drug Treatment Court process. And in doing that, we can take a host of remedies, auxiliary programs, put the child through a course of developmental experience where the child has the option to graduate from the program and have a certificate of graduation. Constant supervision, constant reporting back to the court. But very importantly, in both the Children Drug Treatment Court process and the peer resolution process, we have taken care of the situation where a parent might say, I don't want my child in that. And the court, sitting in its traditional role as parens patriens, where it has supervisory authority and control over a child, can say to a parent who says, no, listen, this is in the best interest of your child, and we will do it without your consent through due process. There is, of course, the right to appeal. There is, of course, the right to knock on the door of the court. There's a right to review. But it is important where parents may have a view different from the court and probation departments and auxiliary departments' view to factor what is in the best interest of the voice of the child, to give the child that second chance. This is what we refer to as the wraparound services in these bills. When we look to the graduation from Clause 56, which is the Children Drug Treatment Court process, and we looked at peer resolution, we have looked at the situation where we have described what the child has to have to qualify for both programs. Both programs allow for lack of parental consent with due process. Both programs allow for a conviction to be avoided. And that is a critical thing for a child. A child who is scarred by the fact that I'm a criminal, I have a conviction, it's on my record, I go for a certificate of character and it pops up. We are giving children the chance to avoid a conviction on the record, but to be under the supervision of the court so that they can come back at any point in time. And that, I think, most respectfully, is society beginning to work right. Madam President, that's barely scratching the surface of the architecture. You couldn't read this out to the Senate in the time that you have, because the real powerful punches in this legislation come, as I said before, in the consequential amendments set out at Schedule 5 to the bill. Schedule 5 to the bill is one which reflects the degree of consultation had in this bill. For the record, I will say that there was widespread local and international consultation on the process and procedures. Locally, the consultations included police, prisons, probation, criminal bar, DPP, Solicitor General, Legal Aid Advice and Authority, Children's Authority, Private Bar, Children's Authority staff, judicial officers, representatives of the National PTA, Ministry of Education personnel, Ministry of Justice personnel, as it then was, AG personnel as it now is, youth development specialists and religious leaders. Internationally, family, juvenile and youth courts in the US and Canada. Children probation and support services in the US. US National Center for State Courts. Study of rules of court in several jurisdictions. Specialists in Jamaica, Canada, New Zealand, England. Study of the scientific research on child and adolescent development and its relationship to delinquency and childcare. Overall, the judiciary has concluded that this is a step in the right direction. But importantly, what we had to do was to factor what the amendments, as I said, were going to be to the laws to make this thing work. You see, I have come to understand, having traversed the number of laws dealt with in the last Parliament, the 10th Parliament, you could tick the box all you want on the laws. Unless you operationalize the laws sensibly, you just have a checklist, a laundry list. You've not got it done. And what we have spent time as a government doing is literally, to use the expression I heard in Jamaica recently, we're building a plane while we're flying it. Sorry to put it as crudely as that. Whilst we have been piloting these laws, looking at it, we have sourced, the judiciary of Trinidad and Tobago has sourced the buildings to house these courts. 2 buildings. 1 in Tobago. The judiciary of Trinidad and Tobago, along with the Ministry of Public Admin, has looked at the human resource capacity to staff the courts. Discussions with the CPO have been factored and lined up in gear. Transfer of terms and conditions, etc. You see, if you wait to do this thing in series, 10 years from now, we'll be having the same conversation. And what we can say is that for once, we as a country are considering operationalization at the same time as the legislation. And that is why you get a work product like this before the Senate, where you don't amend 3 pieces of law, consequentially, you amend 18. And I can tell you this, we could have gone on and on and on and found more and more and more. But there's just a point where you have to accept that perfect isn't the result you're looking for. Let's get it moving in the right direction. And this is not only an exercise of diligence, this is a labor of love. And I wish, if I could press pause for a moment, to publicly commend, yet again, the technocratic team that worked on this bill. They included the Office of the CPC, Chief Parliamentary Counsel, Mrs. Angela Moore, Mrs. Carla Ali, the Juvenile Court Project, headed by Master Christiane Morris Allen as the project manager, Ms. Gayatri Paragas as their legal consultant, Ms. Donna Bucco, the component manager, Ms. Shari Niles Hippolyte, the legal officer, the Children's Authority, its chairman, Mrs. Stephanie Daly, and a host of others, because the Office of the Prime Minister, Permanent Secretary, Minister Ayanna Webster Roy, the Office of the Attorney General, the Secretariat of the Attorney General, everyone has come together and pushed for the development of this purpose. And on this occasion, I'm very pleased to also publicly commend the opposition and the independent bench for participating in the Joint Select Committee, as they did, for taking the mountain of work that I confessed I put on their backs, because what we did is to put every piece of consequential amendment into the law which we amended. We track changed the version. We put the amendments inside of it so it could be comparatively factored. We wrote out to the public sector societies. We got contributions back from them. We've opened a whole conversation on another area of law in the age of contracting of marriages, which we've dealt with separately because of the mandate of this committee. You can't step outside the mandate of the committee. We received submissions from equal opportunity observers, and you'll see in the verbatim notes of the Joint Select Committee, in the report put before this Parliament, some very interesting commentary by Senator Ameen, raising an issue, Senator Ramkissoon raising an issue in how we treat with where the law needs to explore further amendments. Because it is only by way of fact-driven data that we're going to get there. And I'm very pleased to say that the record at the Attorney General's office for the last 8, now 9 months has been, we are fact-centered, data-driven, and we produce the information for public consultation and for public consumption, so that intelligent-driven analysis is factored on the back of Trinidad and Tobago data, not data in the United States or in England or New Zealand. we now have data in our local jurisdictional context. How much time left? 10 minutes, 11 minutes gives me barely enough time now to traverse, Madam President, through the consequential amendments as I went on a slight tangent of necessity to pay congratulations and thanks to the many sleepless nights spent by the technocratic team and to all members that participated. So, Schedule 5 has amendments to 18 pieces of law. The 18 pieces of law which we amend are very important material to articulate along with this process. The consequential amendments are to Supreme Court of Judicature Act Chapter 401, the Bail Act Chapter 460, Summary Courts Act Chapter 420, the Administration of Justice deoxyribonucleic acid, sometimes TRIP, Chapter 534, which is the DNA Act, the Legal Aid and Advice Act, the Probation of Offenders Act, the Indictable Offences Preliminary Inquiries Act, the Prisons Act, the Young Offenders Detention Act, sometimes referred to as YODA, the Police Service Act, the Matrimonial Proceedings and Property Act, the Adoption of Children Act, the Status of Children Act, the Family Proceedings Act, the Children's Authority Act, the Children's Community Residences, Foster Care and Nurseries Act, the Children's Act itself, the Indictable Offences Committal Proceedings Act number 14 of 2014, not yet assented to or proclaimed, but still standing as law, sorry, not yet proclaimed, but still standing as law nonetheless. And in going through those 18 pieces of law, there are a few of them that I wish to flag out, because obviously it would be difficult to go through all of them. In flagging out this architecture, obviously, in the Supreme Court of Judicature Act, we're raising the number of puisne judges, or High Court judges, from 36 to 49. The bill itself says how we're going to deploy the masters and judges that we have created posts for. In the Bail Act, we have specifically gone through the requirement that a child is someone under the age of 18 years, and what we have done is to factor how we treat with evidence to be taken, unsworn evidence for persons under 10 years of age, and sworn evidence in criminal proceedings for persons above 10 years of age. In the Summary Courts Act, we have again reflected the same position as we've done in the Bail Act. In the DNA Act, we have done something which is critically important. DNA Act, Status of Children's Act, and the Police Service Act, we have covered a loophole which we raised while we were in opposition, where the information, the personal information, fingerprint data, DNA data, was not protected for non-intimate samples. And the case of R.V. Marpa, as it went to the European Court of Human Rights, came squarely to rest at home. We took the opportunity to insist, if you're going to take non-intimate samples, and you're going to take fingerprint information or photographs of children, that it had to be protected in the same fashion as you protect for intimate samples. We specifically, in reflecting on those three pieces, disaggregated the difference between the DNA evidence which you take for criminal proceedings, which is done by the Forensics Institute, and that which you do in particular for the Status of Children's Act, where you establish paternity. You see, the law as it currently stands unamended is that you use a hematologist to give you a blood type to tell you who is not the father by way of conclusive statement or inconclusive statement, when the state-of-the-art technology as to 99% accuracy is in fact DNA legislation. And because the child's right is so important and the voice of the child is so important, we needed to modernize the systems but protect the data at the same time. When we look to the Legal Aid and Advice Act and we factor the amendments to the Children's Act, and we look to how we articulate between the roles that we have created, the Solicitor General's Department under the AG's office has child advocates. The Legal Aid Advice and Authority, again, has a form of children's attorney. There may be a private children's attorney. What we needed to do was to harmonize the protection of the voice of the child, so that if you're at a police station and the child comes into a situation where you believe the child needs assistance, or in any event, anybody, parent, police, children's authority, can call for a child advocate to be present while the statements are being given to protect the interest and voice of the child. When we look to the Prisons Act, and we look to the complete reformation of the Young Offenders Detention Act, we are taking a bifurcated approach. We're telling the Children's Authority, you as the licensor of children's homes and rehabilitation centers, the supervisory factor, you have certain powers. But children who are on charges and in remand, or are convicted children, fall under the supervision of the Commissioner of Prisons. And therefore, you have to have an interrelationship between the supervisory aspects of the Commissioner of Prisons and the Children's Authority. And we've done that by putting a hybrid approach with an advisory board. Madam President? Thank you. I was now thinking I had a little more time. The Young Offenders Detention Act, we are refashioning into a Children Rehabilitation Center Act, and that says it all. Taking this concept of the juvenile, converting it to the child, looking to the interests of the child. We are very importantly allowing the provision of the Matrimonial Proceedings and Property Act to work. We are allowing for orders in favor of a child, even on an international reciprocity of enforcement basis, to ground tighter. The Adoption of Children Act, we now have the ability to bridge that 6-week period in terms of where you place the child, not the consent of the mother, which, as we know, through lactation or other issues may have psychological issues relative to consent or affect consent, but we're allowing for a child to bond faster with potential family, to the adopted family in those circumstances. And that's a very important thing. We ban the position of payments for children. We put the Children's Authority as the facilitator of applications to the court. We're removing the concept of disaggregating the pieces, getting the best qualified entity to approach the courts to get this area done in the best interest of the child. The status of children I've touched on already. In the Children's Authority, we are very importantly allowing for the provision of temporary or conditional licenses. And the same thing for children community residences, because the 3-month period permitted to allow for licensing long passed, and people could not apply. Again, through reasons which I can't explain, but perhaps someone else can, the law was operationalized without the system being ready. Last Attorney General and one before would have had the responsibility for that. They are the same people in court applying for damages for the people on the operationalized law. I can't explain that. And I wouldn't go down that road today. That's for another occasion. The Children's Act, very importantly, we're clarifying this role, as I said, of duty counsel, child's private attorney, and the interview with the child, etc. All in all, 2 minutes left as I have. Time could never do justice, 45 minutes as we have, in this sitting, to the massive amount of work which was done in getting this bill ready, to the months of slaving replicated over years. Because when you reflect from 2001 to 2016, that's 15 years, and there was a whole time prior to that. Finally, we are looking in the right direction. We are operationalizing at the same time that we legislate. We're looking at human resource, budget, provision of finances. There's a coordinated effort. I salute the judiciary of Trinidad and Tobago for pioneering data-driven work as we have. I thank most kindly the very gracious benefactors and donors that have allowed Trinidad and Tobago to have the beneficiary support funding from USAID, etc., United Nations, and most importantly, the sheer will, the sheer desire for success demonstrated by the people that work in this system. Trinidad and Tobago could never repay that debt of gratitude. The people at the Children's Authority, Chief Parliamentary Council, the various agencies who have done the work are heroes of Trinidad and Tobago that we must all openly salute. Madam President, I wish to thank the Secretariat to the Joint Select Committee for the hours of work put in, and with these few words, I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Make Jurisdiction for All Family Matters and Children Matters Exercisable in a Division of the High Court to be called the Family and Children Division and to make provision for matters connected therewith be now read a second time. Senator Ameen.
Thank you very much, Madam President. Madam President, I thank you for the opportunity this morning to contribute in this debate to establish the Family and Children's Division of the High Court of Trinidad and Tobago. Madam President, I am particularly pleased to be given this opportunity because the welfare of children and their protection has been a personal passion of mine, and more so has been a matter that the party to which I belong and the leader, former Prime Minister Kamla Persad-Bissessar, made many meaningful steps when it came to action to protect the children of Trinidad and Tobago. Madam President, I listened to the Attorney General as he emphasized on the work and the research that has been done in preparation for the bill that is before us. Madam President, the Children's Division, the Family and Children's Division Bill, received the most amount of attention and work under the People's Partnership Government under the leadership of Kamla Persad-Bissessar. And this initiative is one that many in the fraternity at work with children were very well receptive to. Madam President, what would make this venture worthwhile is for the government and my colleagues opposite to ensure that it is proactive in passing legislation like this and not to wait until it is too late. But more than that, I want to issue a bit of a warning, I should say, that the protection and rights of children is not a public relations exercise or a game. The required work to be done in the areas of providing infrastructure, to ensure that there is sufficient funding to organizations that operate to make this, to implement and carry out this work, such as the Children's Court, which is to be established, but the Child Protection Unit of the Police, Trinidad and Tobago Police Service, and the Children's Authority of Trinidad and Tobago needs to be carefully looked at. The Attorney General indicated that at the committee, several members did mention the need for other pieces of legislation to be examined to ensure full protection of our nation's children. But this government would be really only doing lip service if it were not to ensure that the necessary support is given to all the agencies, including the one seeking to be established today. Madam President, in my presentation today, I want to reiterate the People's Partnership commitment to ensuring the protection and welfare of all children of our nation. I want to emphasize the importance of the following to successfully implement this Family and Children's Division Bill. The infrastructure that is required, the courtrooms and the court spaces that are suitable for use where children and family matters are concerned. 2, to further legislative support required to ensure the protection of children. 3, the funding of units, agencies, departments, such as the Children's Authority, the Child Protection Unit, and the Family Court, and to provide the necessary state support to these agencies. Madam President, it was under the former People's Partnership government, Kamla Prasad Bisesa as Prime Minister, announced the inauguration of the Children's Task Force, the Child Protection Task Force, on the 1st of December 2013. Madam President, among the objectives for the task force were to commence and complete review of all provisions, regulations, legislation, and public processes to protect children, to provide recommendations on the issue, to create risk resolution on specific risk areas which will require state interventions, to suggest how early warning systems can be structured, to provide for the detection of the protection of children who live in at-risk situations, and the provision of sourcing, improved counseling, and specialist care services for children. Madam President, ironically, the first meeting of the task force was called on Friday, 6th December 2013, and it was held at the Ministry of Gender, Youth and Children's Division. Sadly, Mr. Vice President, one of the first acts of this PNM government was to get rid of the ministry responsible for gender, youth, and children. And it has been reduced to a division. In fact, a division within the office of the Prime Minister. And in fact, that only came about after protests and objections from civil society and from the opposition. In the past, I have called on the government to re-establish the Ministry of Gender, Youth and Children's Development, and I want to repeat that call today. Madam President, in giving the Children Protection Task Force the support to do its work so that the Attorney General could talk about all the work that has been done in the past, I looked at the Child Protection Task Force report to Parliament from March 26th of 2014. And in the report, it indicated that the Children's Authority, that Cabinet had approved the authority's org structure of 242 staff in June 2013, the Cabinet of the People's Partnership Government. This would constitute the staff complement required when the authority becomes fully operational in multiple locations. For startup, when services are initially to become available to the public, the authority has determined that the 97 staff in key positions are necessary. The Prime Minister's establishment of the Children's Task Force was made with the mandate to cover the provision of salaries and so on, and with the cooperation of the CPO's office and the Ministry of Finance, the task force assisted the Children's Authority to ensure that that was done. And after receiving approval of its compensation package in early February 2014, it has recruited 41 of the 97 approved staff positions, and it was expected that the authority will be fully staffed and initial training completed with all of its departments in operation by September 2014. Madam, Mr. Vice President, it is not just about talking the talk, it is about walking the walk. Mr. Vice President, the report of the task force was delivered to Parliament within such a short space of time, and that I think it would be remiss of me not to mention some of the persons who worked passionately almost all their lives in Trinidad and Tobago, but also with other countries and the United Nations. And when the members of that task force were nominated, they divided themselves into subcommittees, and I specifically want to mention Mrs. Margaret Sampson Brown, who chaired the Committee on Policy and Procedures, the Mrs. Hazel Thompson IE, who chaired the Committee on Legal Matters, Mrs. Hazel Brown, a stalwart in the advocating for the rights of women and children, and Mrs. Stephanie Daly, of course, who chaired the Committee on the Children's Authority. And their work really was done in such a short space of time, and it really had to do with their own expertise and passion. And Madam, Mr. Vice President, in the time that the Children's Authority became established, there were a number of reports, very alarming reports, in the public of children being abused, and the state's lack of ability to treat with these matters. And the work of the task force at that time was so urgent, and it could not have been done without the government giving that power to the task force to ensure that things came forward. But, you know, as with all things, you have the legislation, you have the good intent of some, but it requires the fairness on behalf of those who are here now to ensure that the implementation really does take place. Madam, Mr. Vice President, the one other agency that was established under the and expanded under the People's Partnership Government, the Prime Minister at that time, Kamla Prasad Bisesa, MP, who was chair of the National Security Council, indicated that the Child Protection Unit was proposed to the Acting Commissioner of Police, Stephen Williams, to deal with underage sex offences. The special unit of the police service will focus on offences against children, including teenage pregnancies, and this was one of the immediate steps to be taken following a meeting of the National Security Council, which was announced by the Prime Minister at that time. While speaking to the media, the Prime Minister said that the Council decided to expand the terms of the Child Protection Task Force for research and review of the issues and to provide recommendations to treat with it. Not only were they further empowered, Mr. Vice President, she added, and I quote from a Newsday, a Guardian article of Saturday, February 8th, 2014. She added that 1,000 people are to be recruited for the police service and 500 for the Special Reserved Police, SRP, in the coming weeks to bolster the police service. That is, Mr. Vice President, to ensure that they do have the manpower to carry out the work that is required. And you know what? Fast track to Sunday, January 17, 2016. This year, Child Protection Unit overburdened. And if you would allow me to quote a bit from the article, overwhelmed by heavy workload, insufficient staff, and the absence of proper streamlining mechanisms. And members of the CPU, the unit of the Trinidad and Tobago Police Service, said that they were fearful that the unit, conceptualized to protect one of the nation's most vulnerable groups, could instead be shortchanging them. The fledgling CPU, which came on stream in May 2015, with a mandate to ensure the rights of children are protected under law, is governed by 3 pieces of legislation: the Community Residences, Nurseries and Foster Homes Act, the Children's Authority Act, and the Children's Act. However, police officers were becoming increasingly disenchanted and burnt out on the job. One of the unit's major concerns was the absence of safe homes to put the children, who were mainly abandoned and abused. Many of the homes were closed down, and there are no residences for them, as it is supposed to be. And because of this, in many cases, the children are left with the same perpetrators, as it becomes a vicious cycle of abuse. They also, Mr. President, indicated that the DMOs, the district medical officers, to whom abused children are referred, are also overburdened, and they have their own work to do. I mention this to reiterate how important it is for the government to not just talk and bring legislation to Parliament, but to ensure that the state agencies responsible have the support required, that what is required to establish and register and monitor residences for children who are at risk, the administrative support not only for the CPU but also for, and this is why again I believe the Ministry of Gender and Children should be brought back to give a full support to the structure that will establish the residences and monitor them. And so far there are 9 police divisions of Trinidad and Tobago Police where the CPU is established. But certainly the education and training of these officers must be continuous, and it requires funding. It requires the will of the government to ensure that those in charge, the acting commissioner of police, has the resources to do the work. Mr. Vice President, I also want to remind where the construction of the courthouses are concerned. The People's Partnership, when we had a Ministry of Justice, had made a commitment to ensure that, to deliver on the promise to the people of Trinidad and Tobago to modernize the administration of justice in Trinidad and Tobago. In early 2013, the partnership agreed to spearhead construction of 4 judicial centers, one in Sandy Grande, one at Trincity, one at Carsonfield, and one in Siparia. Unfortunately, though, there were members of the lower house, I remember in particular, who made very vociferous objection to the construction of these administrative centers. If we are speaking about the modernization of justice, if we are speaking about increasing the efficiency of justice, and where we are talking about having an environment in a court that is conducive to children and family, when we speak about having more mediation and counseling, we really cannot do it in the present atmosphere that the courts operate in. And so while I know that the people who are part of the family court at present will work with whatever their circumstances are to make it good, the onus is on the government to ensure that construction of these judicial centers begin as soon as is possible. The dignity of the court should be maintained. The designs agreed to under the People's Partnership Government really reflected a shift in paradigm from retributive methods of punishment to include restorative techniques for offender management. And you don't just call it treating with criminals, because children, I mean, children very often are offenders, and many of them, with the support, can go on to lead very productive lives. But we must also ensure that our courts are easy to access for all users, members of the public, the differently abled, children, families, and within those spaces, too, the partnerships plans for these judicial centers. There were allocations for the Legal Aid Advisory Authority for mediation and for probation services. So with this, I want to urge the government that the spaces to be utilized for these courts must be given priority as well. Mr. Vice President, I want to also mention that the Trinidad and Tobago is a signatory to several international conventions. The United Nations Convention on the Rights of a Child, which we signed in 1989, the Declaration on the Survival, Protection and Development of Children, which we signed at the World Summit for Children in 1990, the Millennium Development Goals, which came out in 2000, which we are also a part of, and the World Fit for Children in 2002. And in this Senate, the first motion to be debated was brought by opposition Senator, my colleague Senator Wade Mark, and it was a motion for the government to adopt the United Nations Sustainable Development Goals. Yes, it was the first private motion to be brought to this House. And the Agenda 2030, the Agenda for Sustainable Development, and all members of this Senate voted in favor of the government of Trinidad and Tobago adopting the 7 Sustainable Development Goals. And out of the 169 targets, covering a broad range of sustainable development issues, it includes, and I just want to mention these because they have an impact on how we treat with children, ending poverty and hunger, and improving health and education. And the rights of a child really are guided by 4 principles: the best interests of the child, respect for the views of the child, and in this piece of legislation you would see where the child's right to have a view is given opportunity to be recognized in law, the right to life, survival and development, and non-discrimination. Where non-discrimination is concerned, the state parties undertake to respect and ensure that the rights and identified in the apply to every child without discrimination of any kind, that they have equal access to services and protection. Mr. Vice President, with that in mind, there were several recommendations that did not make its way into the legislation that is presently before us. There was a recommendation for the Children's Ombudsman, who will treat with matters pertaining to the welfare of children. And in our administration of state, we do have an ombudsman who is so overburdened. He treats with every matter, and I think there were so many different sectors who are asking for their own ombudsman. Coming out of local government, I know that there were requests and proposals. The Minister, the Honorable Senator Franklin Khan, would be familiar because as part of his work in local government, there are people who are saying, let's have a local government ombudsman. And so there is also a call for those who deal with the rights and protection of children to have an ombudsman responsible for matters pertaining to the protection of children. One other matter which I know at some point we will have to treat with was to take a more gender-neutral approach to treating with sexual offenses in children, to treat with the issue of teenage pregnancy. And so it is not only about who commits what offense, but where we go from there. Mr. Vice President, before I wrap up, I want to take this opportunity to pay tribute to those men and women in Trinidad and Tobago who have been working for decades to ensure that our cultural approach to the protection of children is developed, who have been advocates regardless of who is in government. I want to pay tribute to the people who worked to ensure that this piece of legislation before us, which looks at a number of issues, that they were able to bring it forward. But more than that, Mr. Vice President, I want us to ensure as a parliament, while our job here may be to talk, what matters when it comes to the protection of children is the action that you take. So all of the things that have been described would only be fancy words if you do not put it into action. And Mr. Vice President, as I close, I want to again repeat my call for the establishment, the re-establishment of the Ministry of Gender, Youth and Child Development. I want to again call on the government to ensure that the assessment center, which caters specifically for abused children who come before the Child Protection Unit and is supposed to fall under the Children's Authority, that is established, that it is a building is constructed for that use, and to ensure that the judicial centers, which were proposed by the People's Partnership Government, get attention to construct the new buildings to ensure that the administration of our justice in our country, and especially when it comes to children, gets the attention it deserves. I thank you.
Senator Ramkissoon.
Thank you, Mr. Vice President. Let me firstly say good morning, Mr. Vice President, to all. It's such a good thing to say that on this chamber, to be here so early and start right. It's a good thing. It is truly an honor to join in this debate to talk about the act to allow a family and children division to the High Court to deal specifically on family matters. I was given the privilege, as highlighted by the Honorable AG, to be part of the Joint Select Committee. Mr. Vice President, just for information, 5 members were appointed from the House of Representatives and 5 members were appointed from the Senate to be part of this Joint Select Committee. After being part of the Joint Select Committee, I must say the independent bench is much different to the other benches. The government can caucus and have their 5 members. The opposition has the opportunity to caucus, but the independent bench doesn't have this great opportunity. So I must say the views and expressions and thoughts that was expressed during the committee were strictly mine and from the research. So after that, I must appeal to the members who write the standing orders to look at probably inviting more than one independent members who have different backgrounds to be part of the team, and to really, I see some merit in looking at that. So, Mr. Vice President, I have tailored my debate to outline some of the key points revealed during the committee work as it relates to this bill. As well as I always ask all to be very open-minded and to acknowledge recommendations that may come from all members who participate in this debate, because we always want the best way forward and the best bill to go forward. Now, this bill is quite important to me, as I have served my country in a smaller capacity doing community work in South Trinidad and Tobago. And I have seen where children face, and I have seen the scenarios, cases, I've heard their cries, I've seen how they feel in these foster homes and what they face. I sometimes think children's homes are a bit like boot camps. You have a fixed time to eat, a fixed time to wake up, a fixed time to go outside. It's very, very programmed. And that is what you expect when your child is going into a foster care or into a children's home. But you have to expect this because it's a large number and you have different diverse situations. I do remember a particular case that really touched me where this child coming into foster care, when he was given a bed, he didn't sleep on the bed. He slept on the ground near the door because he was familiar with that. And that is cases that exist in Trinidad and Tobago. Just in today's Guardian, there was an article, Big Spike in Child Abuse Cases by Annalisa Paul. And it showed that about 1,300 reports of child abuse in Trinidad. So we all love children. We love their innocence. We love that they are fearless. And the children didn't ask to be part of their home or their parents or anything like that. But parents who are addicted to drugs, gambling, they have different scenarios, history, and they are just part of the abuse problem. Now, we all know that parents might give you birth of life, but love gives you the reason to live. So I recall dealing with cases where kids were separated from their parents, and the first question they will ask you, Madam President, who's back with us, is, when will I go home? When can I go home? Regardless of what background they may have faced. And I was blessed to have loving parents who really taught me at an early age how to be compassionate, how to give back to society, and really how to be grateful. And I really was happy to see that this Family and Children Division bill is before us, and I must say that I support this bill. And as the Attorney General in his initial statement, he says that this is a pilot project. And that stood out for me in the committee stage. We have been piloting for the last 12 years, so I hope we have got it right now, and we can now go to the different stage of the process. So I do support this piece of legislation. Now, the focus. The Family and Children Division Bill is really focused on children reformation and second chances. As a child who commits a murder will be suffering serious mental issues, which is very difficult to deal with when a child is birthed into a family of violence and abuse. Now, we all know that love covers a multitude of sin. And even the Attorney General spoke about a labor of love. And I personally know of second chances where children, brilliant minds who came from children's home, go to prestige schools, win scholarships, become active members of society and giving back positively. I personally have a young man who lives in my community, and I have adopted him as my little brother. He is very sold out for the Lord. He's a fabricator, he's a welder, and Madam President, he came from Laventille. And he was adopted by a family in my community who is strangers. So people can give back regardless of where they come from. Children is not the root of evil, it is their environment or their background. And we have the chance to make a difference. Many times society unfortunately stereotypes. And for example, if you're from Cedros, all you can be is a fisherman. I disagree with that line of thinking. I believe you can be anything that you want to be. Yes, you can be a doctor, even though Mount Hope is probably 3 hours away from where you live. But Madam President, we as members of Parliament need to be aware of these scenarios and really provide opportunities for these children to be more than what their situation can present for them. Madam President, allow me to share a personal experience that I had this weekend. And it really shared the humanity and why I love my country so much. And it really ties into our family and our children and really what we teach people. Madam President, it was my very first time I've entered a half a marathon. I'm very impressed that I can stand before you all today. Yes. And the one thing that got me to finish was the people. Not the organizers, not the runners, not the competitors, but the people. They came out of their homes, Madam President. They cheered you on. They said every good thing possible about you to finish. Almost there, I remember reaching 15.5 kilometers, and I stopped, and this guy just ran out of his shop and said, "Come on, you're almost there. I'm your #1 fan." And this, Madam President, meant so much to me because this is our people. We always forget the good. We always tend to, because we see the media publish so many negative things, we see our papers, it breaks your heart. But Madam President, to see the good things, and this is why I said I was going to serve my country, and I was so good. It was so refreshing to see this weekend. So, Madam President, we want to live in a community or a country with world peace. We want freedom of speech. We want harmonic living, and we definitely want gender equality. And this bill before us really seeks to bring concerns and queries at a point where you can have a resolution way forward, and not really as outlined as a conviction, but really a second chance doing something. And I really did welcome the committee work. It was definitely a learning opportunity and definitely a different spin to work as a legislator. So the bill intends to implement proper organizational structure that will prevent large backlogs of cases. Also, the jurisdiction and powers in the family matters and children matters exercised by the High Court and summary jurisdiction are to be transferred to the Family and Children Courts Division. So basically, we're taking off the High Court and we're using the Family and Court Division to deal with all the family matters. One thing that I learned in the committee was that the court building intent is to be a safe zone or haven to reduce stress and to facilitate open discussions of issues and provide families with support, hope, and alternative solutions. Other than Port of Spain, there are 2 targeted locations, one in South Trinidad to be delivered by November 2016, and one in Tobago to be delivered by the end of 2017. Now, I hope that the Honorable AG can give us these assurances if this will be happening in his wind-up. I also learned about the DNA testing facility, which would be OSHA certified, and the bill had provisions for other recognized facilities to be added by way of order. We heard briefly, Madam President, about the peer resolution, and I find this a very commendable method of dealing with children who have done minor offenses, such as maybe they went to the computer lab in their school and stole the mouse pads and they were caught. I think it's very, very good to have teenagers trained to deal with children who are committing offenses, minor offenses in the school, and seeing quick actions of resolution and seeing accountability for your actions, and this was good. I must say that teenagers are much more strict judges than adults because they see things in black and white. We might be more lenient and put ourselves in the shoes of another and say, well, we understand why this was done. So I must say this is a very strict way of dealing with peers. It's commendable, and I know there's a training, and some of my friends are part of the peer resolution initiative, and they are very willing to start the work. In accordance, Madam President, to Clause 35 of the bill, the use of the children attorney, which is really for the voice of the child, and it would not be in every particular case that you would need a child attorney. And I also learned that this is different to your defense attorney. So your child authority representative is not your defense attorney, so you will also have a defense attorney representing the child. But this is really to have that flexibility and confidence in the child to give a response. Madam President, in relation to the probation officers in Clause 39 and 38, to monitor the child's compliance with the sentence and sanction and to ensure that the child is assessed for risk at the appropriate periods is commendable. Now that we have probation officers, we can look at using electronic tagging for these children as a measure of keeping tabs on offenders. So, Madam President, what I've learned about the Children Court, it is tailored on rehabilitating and reintegrating children to be productive citizens in our society. Now, there was some statistics shared. Over 90% of the matters determined in both courts took 7 months or less to be resolved, which is really a fast process. This solution is proving to be an appropriate type of solution, as it was even shared that less than 46 cases were cancelled prior to the pre-mediation and in light of the workloads of the social services. So we are seeing less matters going to the court stage because of this resolution process and different types. Madam President, we also heard of extended funding that would be given to our country if we met deadlines of before the end of June. And I read recently that St. Kitts and Nevis launched their juvenile justice reformation project, and it was commended by the U.S., and they were even funded $900,000. So if this is for us, that would be also good. Now, Madam President, we were given these bill essentials from the Parliament. And one of the countries that stood out to me that I thought was very commendable was the Canada Youth Criminal Justice Act 2000. And it spoke about adult sentences are given to the more serious violent offenses committed by youths 14 years and over. Now, we are dealing with children, or a child is classified as under 18 years. And I brought this up as something that I thought was noteworthy, because for serious crimes, can a child who commits a serious offense, who is 14 years and over, be tried as an adult? Now, this may not be something that we can think of, but I asked all to reflect in 2006, a case study with one of our angels that touched every single heart in Trinidad and Tobago, Sean Luke, who was buggered to death by a 13-year-old and a 16-year-old. And I remember society was crying out for these young teenagers to be tried as adults. Now, I've learned that our system does not take that into consideration for trying minors, in this case, as adults. But cases like this, Madam President, we need to ensure that we have it covered and we look at it. And so, Madam President, I'd like to move now to some work that was done by the Family Court Monitoring Committee. And they have published a first and second year consultation report where they made recommendations for effective and efficient operational strategies, tasks, and processes. One of the areas that stood out to me that was surveyed was for staff survey 59% of the respondents who took part in the survey found that internal communication was adequate. So 41% thought it was inadequate. Another point, 65% states that at least 2 areas in which procedures and practices could be improved at the court, and also identified specific areas to be addressed. So that's processes and procedures that could be tightened. Another area, 51% agree that improvements were needed to procedures related to their specific job. Again, job descriptions is always a weak point in our country and always needs some tightening. Another point was attorneys working in the family court noted the need to improve strategies to deal with the service of summons. And the last point that stood out for me was the assessment of the medical, psychologists, and risk assessments to be conducted for each of the cases. There were merits in looking at these recommendations and really closing them, because I don't know if they were addressed, because we need to close the gaps in these areas as we move forward to have other courts in different locations in our country. So, Madam President, I would like to now look at the Children Drug Treatment Court process, which is from clauses 47 to 58. And I would expect we are talking about illegal drugs and not over-the-counter drugs. And so we are dealing with minors and drugs. And just a note, recently in our public domain, we were learning of consultations for legalizing marijuana. I don't know what is the stage of the consultation process, but I would like to use this forum to just say my thoughts on that. Knowing the culture in our country and learning of, well, we're actually having a drug treatment facility to deal with minors and alcohol abuse and drugs, illegal drugs, to now legalize a substance that is presently legal. I don't know what control systems that will ensure that we have enforcement to have such preventive measures in place. It is very difficult presently to prevent minors from gambling, from smoking, from drinking, and just participating in vulgar activities. So unfortunately, I am not supportive of that at this time unless we can prove that we have alcohol in control, we have gambling in control, these measures in preventive. And I can even share an example with you, Madam President. Recently, in 2014, there was this movie done in Trinidad and Tobago, which was entitled Girlfriend's Getaway. I didn't look at it at the time, but after getting all the credits, and they spoke so highly about this movie, of local being on a map internationally, I said, okay, I will look at it. I, Madam President, was not a fan of this movie because it promoted poor customer service, getting drugs from a friend. It spoke about illegal activities that they highlighted to the police who could not solve the crime. It showed vulgar dancing in the streets, and I couldn't believe why we as Trinidadians was proud of this movie. I couldn't really understand. I don't know if anyone saw the movie. No, okay. And it really highlighted us as a bit of lawless society, and maybe we accept it to a point, but as a member of parliament, I felt that is not something we can accept. So to look at the drug abuse and the treatment, we really need to have preventive measures in place and really have that enforcement measures, and it really goes all the way from the top to the bottom for persons being held accountable for what they're doing, for their jobs, have a kind of pride, self-pride to motivate yourself to do the right thing. Madam President, I also got the opportunity to look at the Western Australia Children's Court of Western Australia Act, which was published in 1988. And I liked how they dealt with their drug court system. And it used a breach point system to respond to compliance and non-compliance, but it operates in reverse. So when you enter the drug treatment facility, you're given 20 points. If you do good things, you gain points. If you do bad things in the system, you lose points. And I thought that was a great method that we can look at when we are writing our regulations to running this particular facility. Now, Madam President, I must say at this point, prevention is better than cure. We always tend to praise the cure rather than the prevention. So when we see a building burning, we always say, we give praise to the firefighters, we give them a medal, we give them promotion, we give them, we always highlight them for their good work. But we don't ever highlight the electrical engineer or the electrician or even the person who's monitoring their panels to make sure it's not overheating. We don't ever look at the preventative strategies. It's working good, it's not broke, we don't fix it, right? So we never tend to look at the preventative. Our society is like that. It's just, well, probably the world is like that. We tend to look at the end result rather than what we have done to get to the end. And I feel it is necessary at this point in my debate to just speak briefly on something that I can think we as a country can look at as a preventative measure. And I always speak about, and when I'm speaking, about the root cause. And if we look at our society and we look at the root cause of our family and children division, the cases that come forward, we can look at, despite the growing crime situation in Trinidad and Tobago, we can look at families or parents having to work longer hours, where both parents are employed and younger children are left unsupervised or in unsafe child care facilities. And this is really about merging your work culture and your family life. Unfortunately, school hours are not designed to fit working hours. Many children have to return from school to empty houses. Mothers and fathers have to entrust strangers to care and raise and instill values into their children at very critical stages in their life, especially the stages where they imitate your every movement. So what we as a society, or what as me as members of the parliament, or what we as the government have done to assist these modern families. Now let's just look around at us. The women in the Senate, Madam President, 9 of 30. If we include you, Madam President, that'll be 10 of 31, which is about 30% of the chamber. And they always talk about we are in the minority. Now, Madam President, we are senators, but we are also expected, to be considered full-time mothers who are not at home, but yet we're full-time. We're expected to hold full-time jobs, but yet we're also senators. And then they still want to know why we are in a minority. So we need to look at gender equality. And really, I'm looking at many organizations now, they are into this health fitness drive. So every building has a gym equipped or nearby. I believe there's a merit in looking at fitting these buildings or organizations or public service with a daycare facility. This building should have a daycare facility because we are here such long hours, Madam President. We have staff, all our staff, and we expect them to be here all the time with us, preparing for us. It is such a merit to have that safety aspect. You can check in, you can look at, because we're seeing it in the newspapers where the care facilities, I think there was unfortunately a case where a child died. And all those things are very sad cases, and we really should look at merging our work culture and our family life. There is a lot of merit in it. So I even got a chance to look at, I love to look at the different acts that we have in our country. I'm always impressed by what's written in paper and what actually happens. But in accordance to the Maternity Protection Act Chapter 4557, the power to make regulations. This is what this area is about. And it says that the minister may make regulations for the purpose of giving effect to the provisions of this act. So we can look at marrying these and really look at writing regulations that will allow public sector or all organizations to have a close proximity, a daycare facility or a primary school or a kindergarten that will really see some merits in it. Madam President, equality is really merging work environment and the home. So when I saw an example that I thought was really exemplary is I only learned of this recently, and it's quite a good business initiative. Madam President, there's a facility in the Central Athletic Club, that has a daycare facility because it's a 24-hour gym. So if they could get it right, we could get it right. So Madam President, I just wanted to share that example. Now my final point is on the Ministry of Education National Policy that was last updated in 2009. And it will be amended, I'm sure. And I think it should be amended to incorporate this running legislation that is before us today. As what is the next step for when the child is being reformed? What is the next step for when this child has went through the rehabilitation stage and now has its credits, they have their point system, they're working, they're good members of society? Do they just go back to school, to the same school? Do they go back to the same standard? Do they go to another standard? You know, all those things need to be considered before we throw them into the system. And it really is a lot of merit in taking the time to write the National School Code policy to reflect such. I saw a very nice quote from Dr. James Dobson. Every child deserves a chance to grow up with a healthy mind and body. Madam President, as always, I always avail myself to work together with all members in preparing and getting to the stage of the best bill possible. And I want to thank you all for this opportunity to share my examples and experiences with this House. And Madam President, I thank you and may God bless you all.
Senator Stewart.
Thank you, Madam President, for the opportunity. It is indeed always a privilege to contribute in this honorable House. Madam President, I rise in support of this bill brought to this House by the Honorable Attorney General. And Madam President, I would really like to congratulate the Honorable Attorney General and all the relevant persons, the technocrats who I would refer to as the masterminds that would have contributed to making this bill a reality. Because, Madam President, anyone that would have carefully perused this bill cannot deny that a lot of work would have been put in. And, Madam President, further to its passage, this bill's passage from the other place, it was sent to a joint select committee on which I myself sat as a member. And I would like to also congratulate all senators, all members that would have contributed at the joint select committee. But, Madam President, before I go into my contribution, I would just like to make a comment, actually just give a reminder. My colleague, Senator Ameen, kept reiterating in no uncertain terms that there should be a re-establishment of the Child and Gender Ministry. But, Madam President, through you to Senator Ameen and all of Trinidad and Tobago, I would like to remind Senator Ameen that this ministry now falls under the office of the Prime Minister in the very capable hands of Minister Ayanna Webster-Roy. Madam President, In reading through this bill, I think for me, what stood out from inception is the explanatory note. And this clearly states, Madam President, that the Family and Children Division Bill 2016 seeks to make jurisdiction for all family matters and children matters exercisable in a division of the High Court to be called the Family and Children Division and to make provision for matters connected therewith. And Madam President, the explanatory note says it all with the 62 clauses providing further support, because the attempt being made here, Madam President, is to speed up matters relating to children and families. And this is with a view to move from punitive justice that focuses merely on punishment to a more form of rehabilitative and restorative justice. And this will be done, Madam President, by ensuring that we would establish what we called a child-friendly court with specifically trained personnel. And Madam President, when I worked as a probation officer in Tobago, on many occasions, clients would say to me, how much longer before I go to court? And this is because, Madam President, a specific day is allotted for children and family matters. And added to that, Madam President, in Tobago, we have 3 courts. We have the first court, we have the second court that would usually deal with family matters, and we have the third court. So whenever a child appears before the court, let's say the first or the third court, the courtroom usually has to be cleared of all persons not related to the case, which, Madam President, tends to be time-consuming. So today, Madam President, before us, we have a bill that is comprehensive. We have a bill that is thorough. We have a bill that is extensive, that will once and for all deal with these occurrences. This bill, Madam President, it places us in a better position to provide structure for court processes relating to children and families. Because, Madam President, by creating an atmosphere that is conducive to calm discussion and settlements without any type of aggression or intimidation, will assist in resolving problems whilst recognizing the sensitivity of this issue. Madam President, and I hold this particular piece of legislation very close to my heart, and this is because of the interactions that I have on a daily basis with children and families in my profession, Madam President. And this bill, it comes to the Parliament at a point, particularly within recent times, when we would have been hearing and seeing some of the most disturbing occurrences with our nation's children and reports of massive family breakdown in family life. So we can therefore relate the clauses in this bill, Madam President, as a treatment to what is happening in our society today. And as I would have mentioned further earlier, the policies and practices provides for matters relating to children to be held once per month. And this sometimes, Madam President, can result in these children getting lost in the system. Because when children are not taken to court on their adjourned dates, they are being denied the right to a speedy trial. Madam President, as I move into Clause 4 and 5, I firstly want to look at Clauses 4 and 5, the Family and Children Division of the High Court. And, Madam President, the Honorable Chief Justice Ivor Archie in November 2014, at the launch of the Trinidad and Tobago Juvenile Court Project, he said in his opening statements, and I quote, "An initiative of this nature is in reality inevitable. Firstly, because the external legislative environment as it relates to children and young persons has changed, requiring us to deal with them differently than before and differently from adults in whatever capacity they interact with the justice system," end quote. And Madam President, whilst I was conducting research for this particular debate, I came across a piece of information that said Trinidad and Tobago ranks 91 of 197 on access to justice for children. And this is according to the Child Rights International Network. This network is a global research, policy, and advocacy organization that ranks country states according to the extent to which their legal systems effectively guarantees children's rights to access to justice. And Trinidad and Tobago tied with Burundi, both having a score of 136.5. So with the approval of this bill, Madam President, we would definitely see our country, Trinidad and Tobago, moving up the ranks. Madam President, the establishment of a children's court can be viewed as an important step in achieving meaningful justice for children and embracing global standards. And this is an adjudication which guarantees the rights of the children in accordance with the United Nations Convention of the Rights of a Child and Principles of Restorative Justice. Madam President, the Children's Act of 2012 defines a child as a person under the age of 18. And when you look at section 63.4, 64.1, and 65.1, which deals with the placement of children in either rehabilitation or orphan homes, it contemplates a situation where children between 10 or 18, or even below 10, can come before a children's court. Madam President, matters of juvenile crime capable of being committed by children 7 to 17 should be addressed in a court specifically designed for children. And over the years, Madam President, and in more recent times, we have seen an increase in the number of children coming before the justice system, whether they come as witnesses, whether they come as victims, whether they come as perpetrators. Madam President, newspaper articles, March 7, 2016, in the Trinidad Express headline, "Boy 11 appears in court for ganja." Further to that, Madam President, Tuesday, February 23, 2016 headline, "Student 16 charged." And Madam President, these and other reports are what have been headlined in the media that concerns children and families. And Madam President, some of the circumstances leading to conflict leading to conflict with the law are of a social nature. The research suggested that children who offend, they sometimes come from families facing difficulties such as poverty, substance abuse, separation. Some of them may even be without a job, Madam President, or excluded from the school system. And when these children enter into contact with the police, the main purpose of the juvenile justice system, Madam President, should be to enable them to not reoffend. Children exposed to violence, Madam President, they may be at a higher risk of engaging in criminal behavior and becoming a part of a violent cycle, which means, Madam President, again, that the court processes should be revised to treat with these occurrences. Madam President, Article 40 of the Convention of the Rights of the Child advocates measures for dealing with children involved in judicial proceedings. This requires young offenders to be treated in a matter which considers the child's age, promotes the child's reintegration and the child's assumption of a constructive role in society, and of course it ensures the availability of alternatives. And Madam President, most jurisdictions in the Caribbean have special juvenile courts or children courts with special legislation and a special branch of the judiciary to deal with children matters. We have Jamaica, we have Belize, Grenada, St. Vincent and the Grenadines, and more recently St. Lucia. Family courts, Madam President, have been set up that allow cases to be dealt with in, of course, an all-inclusive or holistic manner. And the family, Madam President, has a large role to play in assisting with the rehabilitation of the juvenile. And professional help should therefore be provided to counsel the families and to address any family problems that each may be experiencing. Because if this is not done, Madam President, these children will simply be returning to chaotic homes and they would find themselves before the juvenile justice system once again. So, Madam President, let's incorporate a range of specialized professionals. Let's incorporate psychologists. Let's incorporate probation officers. Let's incorporate social workers, operating in a variety of settings, Madam President, so that the focus is shifted to rehabilitation rather than mere punishment. And this administration, Madam President, has responded to the call for the need for Caribbean governments to make a concerted effort to harmonize legislation pertaining to children and juveniles with principles enshrined in international norms. Madam President, General Assembly Resolution 4033, through which the UN Standard Minimum Rules for the Administration of Juvenile Justice has been officially adopted. It states, young people owing to their early stage of human development require particular care and assistance with regard to physical, mental, and social development, and require legal protection in conditions of peace, freedom, dignity, and security. And, Madam President, these children that come before the criminal justice system, these children did not get there by themselves. A whole host of factors would have contributed to these children being involved in the justice system. And, Madam President, with your permission, I would just like to include the psychological aspect as it relates to young offenders in my discourse based on the research and, of course, my personal interactions. Madam President, young females tend to have a higher rate of what are termed internalized mental disorders. This includes some form of depression or anxiety, whilst young males usually have higher rates of external disorders, including oppositional defiant disorder, conduct disorder, and other behavioral problems. And, Madam President, what is alarming is that a child can be diagnosed with oppositional defiant disorder or conduct disorder before 10 years of age. If the behavior persists, Madam President, past 18 years, the person would then be, who would now become an adult, would be diagnosed with antisocial personality disorder. Other risk factors, Madam President, for increasing offending among both boys and girls: biological, prenatal exposure to high levels of testosterone; psychological, neurological impairment such as low IQ; environmental, exposure to dysfunctional families or deviant peers. So, Madam President, with the availability of trained professionals, which speaks to Clause 6 to identify and adequately treat with the psychological needs of young offenders, will assist in the alleviation of repeat offenders. Therefore, there must be a robust support of many if these young offenders are to be extricated from the system and rehabilitated successfully. Madam President, child justice must not only focus on the child, but must identify...
Stewart, I'm sorry to interrupt, but I think this is a good point for us to suspend for lunch, and we will suspend for lunch and return at 1:31 p.m. I'll be generous. We will return at 1:35 p.m. So we'll suspend until 1:35 p.m. for lunch.